So we're doing this next step, and obviously the last step we talked about, the 341 hearing, which is dreaded for debtors to go through. And if you've done everything back here and you do qualify and you've listed everything in the process and your petition is clean and straight and everything is correctly noted, signed, the 341 hearing shouldn't be a big deal. You just be honest and tell the truth and walk through those steps. Make sure you're working with an attorney who will actually go to the hearing themselves, and that you're working with somebody that's credible and has done a good job for other people, and you get a referral. The reason I say that is because a lot of attorneys will do the petitions in their office or have a paralegal do the petitions in the office, and then the reality is they don't even go to the hearings themselves. They simply pay a sort of a traveling attorney $100 and have them show up to do the meeting of creditors. I would suggest you want to clarify that the attorney is actually going to be there and that they're going to do it before you pay them back here at the initial consultation or along the way, and then find out later on that they're going to hand you off to a very inexperienced lawyer or somebody that you just don't know to handle the process at the actual courthouse. So we're going to just kind of finish this step here. And after the 341 hearing, the 341 hearing really culminates after you have your filing date, and usually after the filing date, meaning once that occurs, it's 30 to 40 days, maybe a little longer between filing date and hearing. And after the hearing, as long as everything goes right, usually within 2 to 4 months, you'll get your letter of discharge, okay? And you'll be done, okay? And your letter of discharge is a little different than the case closed, and sometimes the case will be left open, but at some point the case will be closed and the process will be complete. I would say once you get your letter of discharge, hang on to that. Don't get rid of it. And obviously, then your process is completed. There are some steps as far as accountability and making sure that if things change drastically, the court can obviously reach back into your life. But your letter of discharge is a pretty significant step, and essentially it notes that you're through the bankruptcy process, and then at that point, then your case will be closed, and you'll be done with the process. Once in a while, the case will remain open. They're thinking an asset will come in. My name is Todd Corser, and I want to urge you to subscribe to my YouTube channel and also to visit CorserLaw.com.